Welcome, everybody, to Western Law's lecture by Cris van Eijk. This lecture is being co-sponsored by Western Law's Public and Private International Law Research Group, Western Space, and the Western International Law Association. I'm Professor Valerie Oosterveld, and I'm pleased to welcome Cris today. Let me give you a little bio of Cris before I turn it over to him. Cris is an international lawyer researching the international law and history of outer space and its commons. He's also part of the International Law Working Group of the International Astronomical Union and the UN Committee on the Peaceful Uses of Outer Space, Dark and Quiet Skies Conference. He holds an LLM in Public International Law and a BA in International Justice from Leiden University, and is in the final stages of an accelerated BA in law at the University of Cambridge. Cris is a regular commentator on space law and its legal history, and we are so pleased to have him here today. The title of his talk is "There is no sacred timeline, time, variance, and authority in space lawmaking." Before I turn it over to Cris, I just wanted to mention that if you have a question, please feel free to put it into the Q&A as it occurs to you during Chris's talk, and then we'll get to it at the end of his talk when we have the Q&A session. Thank you, and welcome, Cris. Over to you.
Thank you so much. Hi, everyone. Let me make sure my screen sharing works before I get started too much. Perfect. And then gonna do, there we go. So thank you so much. And it's an honor to be here to present my work in a fashion that is so kind of allowing for both discussion and for a more kind of nuanced and deep view. This is a sort of welcome change from the 10-minute rush that even conferences can be. I, like Valerie said, want to make sure that we leave room for discussion towards the end. So please, if questions, thoughts, or general views occur to you, feel free to either note them down or preferably send them in the QA so that we can have a nice chat after. So I'm going to be presenting today on the work I've been doing recently. My presentation is called "There is no sacred timeline, time, variance, and authority in space lawmaking," titled partially inspired by Alonso Garmendi, but mostly Loki. I have not worked in the alligator Loki joke, I promise, but we'll see what comes sort of as we go. And in general, my research here is trying to look at what exactly it means to call an area a commons or a global commons or common heritage, if that's your flavor, what it means to say that, and what it means to make rules or what we call international law to say so in the way that specifically space law was made. In general, in this presentation, I'm going to try and argue that there were things learned in the making of outer space law specifically that have not really gotten a lot of attention, but really kind of set the scene for later international law making. But also that there's a lot that we sort of need to learn, relearn, and remember about sort of the time that outer space law was made that tells us things about international law in general. So it isn't necessarily just a presentation about space that I'm going to give for you today. It's about how international law forms and interacts with sort of practice after the fact. But I do need to do a brief Space 101 to start with. So outer space is the area sort of 100 kilometers-ish and above the Earth. That is a statement that is a lie in many ways because outer space is not delineated. Earth is not a sphere, nor really has a set sea level, and every sort of aspect about space is ambiguous, as you'll see. But in general, it's a region where historically international law has been questionable. It is also a place that in theory all humankind shares. If anyone's seen the news recently, you may have noticed a Russian kind of anti-satellite test a few weeks ago was something people were really worried about because one country seemed to have created, as you'll see here, quite a lot of debate, that red debris. That red line here is just the contributions of one single state overnight. However, if you look at the general picture, what space is and who is using it, it seems as if only a few countries are really active there, at least in terms of pollution. In terms of use, on the other hand, it really is the US. Outer space as a region is almost entirely, like 1 in 2 satellites and above are American. Most of those are Starlink, incidentally. And the UK, which is also a large actor in outer space, most of those are OneWeb, another mega constellation or satellite network. In general, this picture does not look like the global commons that sort of international relations, politics, and law claim space to be. It seems very much as if it is the game of 1 or 2 states. Now, this requires us to look a little bit about into what outer space law is and how it was made. When we talk about space law, generally we're referring to 5 UN treaties that were formed more or less through the 60s into the 70s. We'll go into the history of that in a minute. But there is a sharp drop off in the number of signatories as you go. Now, they were drafted by, oh, this is also, by the way, a lie. Namely, there are hundreds of bilateral treaties as well that inform and kind of explicate space law making through subsequent agreements if you're a VCLT fan. There's also custom and principles and everything else, of course. But these treaties, the UN ones that sort of most space lawyers keep by their bedside and pray to, were drafted by a specialist committee of the United Nations from 59 or so onwards. First, it was ad hoc and then permanent. UNCOPUOS, I'll call it from here on. UNCOPUOS is a really interesting window into the international lawmaking process. And this is where I want to sort of make this something more than space. UNCOPUOS decided entirely by consensus, pretty much as soon as it met in permanent form. And rarely among UN bodies, both at the time and especially since, it had verbatim record keeping, not summary. This is important because summary record keeping was largely focused on the states that mattered. And as a recent paper by Kurz argues, was also the subject of a lot of censorship. We'll go into that later as well. More importantly, space law was made in a heyday of international law, multilateral treaty making that hasn't really happened since. And so it's a great kind of example of one of the first instances where states from around the world in some ways were able to come together to say what the rules were, as opposed to before when it was about sort of a gentleman's agreement, kind of tripartite or quadri-party meeting of European powers, or after when lawmaking turned into sort of a soft law development exercise. I'm thinking Stockholm, Rio declarations, and further. Now, the parts of space law that I'm going to sort of kind of give you as background here, just so you have some understanding of this, are as follows. And I really don't delve into the content very much, just because I know it's a very niche area. But basically, the parts of space law that make space a, quote, commons, allegedly, are free access, that any state should be able to access space without discrimination. The idea of benefit sharing, in theory, which says that space should be used in a way that benefits all countries, and the use and exploration of space is the province of mankind. There's a grammatical backflip there, because space as an area is not qualified as the province of mankind, but its use and exploration is. The international rule of law, the idea that international law applies in space. The idea that it isn't subject to claims of sovereignty, which makes it, as opposed to res nullius, rather it makes it res communis in theory. And the idea of peaceful purposes, that it shouldn't be used for aggression. Now, all these rules are vaguely worded and sort of incredibly up to interpretation. So how does that work? I'm not going to go over the VCLT interpretive rules right now, but essentially, good faith, context, object and purpose, all the words that international law professors like to give students in the first few weeks. But space law itself, because it is by nature ambiguous, allows for a certain amount of examination of what a treaty is or should be, a multilateral one anyway. First of all, it sort of represents, if you see treaties on a spectrum of the product of either agreement, of states coming together and saying this is what we feel, or contestation of sort of a picture of a battlefield that was fought long ago, space law falls very much along that continuum in different ways. Treaties are also at some point evidence of the intent of the parties, or at least that's what the VCLT's fiction likes to tell us. But in other ways, treaties can disguise that intent. I can tell you I've spent the last few months in declassified and internal archives of this, certain powers. And what was being said in the Travo is not at all what was being said in the UN meetings. In general, treaty interpretation, I want to paint it here as a sort of fictional exercise, as something that is trying hard to find a logic in something that was designed in some ways to be general enough to interpret freely. And because, again, as this meme says, because space law was designed to be ambiguous, especially the Outer Space Treaty, it almost always invites an opening into the Travo or circumstances of conclusion or history in some way. Now, let's talk a little bit more about how it was made. Space law was constructed at a time in which the world was changing. That's another reason why it is so interesting to study as a treaty-making process. Between the first satellite and the first space treaty, UN membership increased by half, and most of that was states that had been colonized. Unfortunately, the committee that was making space law was not so representative. The world looked like this, that committee looked like that. You can see sort of who was favored here. Generally, the selection of states to join this committee were managed on a basis of who was thought to be active in space or powerful enough to contribute to space lawmaking. And specifically, Africa and smaller states in Asia and Latin America were seen to not be worth including, or rather maybe would even contaminate the process by raising issues that were seen as emotional or unimportant. Space law itself rather, was made at a time that it sort of bridges two very important kind of periods in international legal history. First was the idea of a third world that was gaining in solidarity over time. You can see those kind of all of the meetings I've just noted, the ones I could find quickly, that were happening over sort of the mid-50s to mid-60s. That graph in the back is UN membership over time. You can see that between sort of the first meetings of space and sort of the heyday of the space debates, the UN saw a sharp increase. It was right in between sort of the start of the transnational environmentalist movement with the International Geophysical Year and Silent Spring and sort of the first records of carbon and its importance to the global climate in Hawaii. And on the other side, sort of the US National Environmental Policy Act, which set quite a tone in the international sphere, and of course the Stockholm Conference. It was sort of during and then just before a lot of the conversations about international trade and the economic system, leading to the declaration of the new international economic order. And it was sort of right after a set of debates about the commons for the seas and also Antarctica, for which there was sort of a normative surplus hanging in the air. A lot of ideas had been proposed, but those kind of negotiations had not been done sort of on as equilateral a basis or as in the Antarctic case, even under UN auspices. And moreover, their conclusions had been quite incomplete. On the other side, we have the UNCLOS debates that led to the Law of the Sea Convention we know and love today, and the Declaration of the Common Heritage of Humankind, which was only a few months after the Outer Space Treaty was concluded. And in the middle of all of this is space. And it drew from a lot of these kind of discussions. And that in itself is an argument that is only now being made in space law. But more importantly, the things that came after learned from it. Now, specifically, we're looking kind of structurally at what was happening here. There were sort of three bodies relevant to this making process, which was the Ad Hoc Committee on the Peaceful Uses of Outer Space, largely more inclusive in some ways than the main debates because it wasn't seen as something that would result in a permanent outcome. Then we have the Committee on the Peaceful Uses of Outer Space, which did not meet for the first 2 years because they couldn't decide how to vote. After consensus was adopted, they started meeting and immediately formed a legal subcommittee. There's also science and technical subcommittees, side note, which is an interesting thing I'll mention in a minute. Then we can come to how their outcomes were debated. On the bottom side of this chart, you can see sort of a general outline of, according to the UN Travo anyway, who was, when these treaties were sort of being discussed. And you can see here that it's, what I'm trying to show is that things like the Outer Space Treaty, the most widely signed and sort of constitutional documents in space, seem only to have been debated for a couple months. Now, the reason for this is because in reality, the map of who was debating what was quite a bit more exclusive. Now, all of this is to say that time had quite a large impact in how space law was made, both in sort of the events that were happening around its making, but also in terms of who was able to speak when. As sort of this timeline goes on towards the sort of later 70s, as the third world got the mic, the international community largely pressed mute, and everything sort of since, let's say, the Registration Convention, mid-70s, has been either widely undersigned, which questions its sort of international legal effect, like the Moon Agreement, or a non-binding declaration. Now we come to variance. You see, there's more to be said here rather than just time itself being important. The actors who were in space and talking about it had very different views of how and what space should be. And actually, I need to go here first. We've already, I hope, maybe heard the general story of outer space, the orthodox history, which paints outer space law as a product of contestation between East and West, and generally imagines it to have been an exercise kind of derived from nuclear non-proliferation or geopolitics in some way, rivalry. But that was only true in a certain sense. And the essence of decolonial work or of history making is that multiple things can be true at once. What's also true here is that for many states, especially the third of the world that had just decolonized, at least in a formal sense, outer space represented a possibility, both a new age in a rhetorical sense, as the Kenyan Legislative Council said in 1961, but also in terms of what it could be. For states that had just come from a colonial kind of, from a set of colonial experiences that now we could label crimes, for them, outer space represented an area or a zone that had not yet been tainted. It also represented sort of, in the same way that now we talk about space as a mirror for national and international politics, it represented an opportunity to talk about the international community in ways that was really important at the time. The UN was going through a crisis of identity in the 1960s as to whether it was, just as Peruvian delegate Belaunde said at the bottom here, the question was whether the UN was just a clearing body for treaties and a place to talk and give rhetoric, or whether it was an actual international constitutionalist project or something that would in some way enable an international community with legal effect. But more importantly and fundamentally, outer space represented, and has always represented, a sort of unity of mankind, a certain cosmic hope, as Natalie Trevino writes, that would enable humankind to transcend of a nationalism that had broken them in the last couple decades. And so in that way, I want to take a turn on the kind of ways we remember space. It started fundamentally as a place of togetherness, of cohesiveness, and as a place of development of a mankind in a way that now is only looked at in the context of the history of the law of the sea. And as something that made mankind or humankind something greater than just each other. Now, here's the problem, is the ways that we painted that picture were very different. Just in how the commons was understood in a rhetorical sense or discursive sense through the space debates shows a marked kind of disagreement with what terms like res communis meant. Here's the problem, and a little window or inside baseball for everyone here. Res communis isn't a rule in international law. you won't find a treaty that really mentions it in a binding sense. It is something that a couple white men made up to legitimize empire, and I'm a Dutchman, so I'm allowed to insult Grotius that way. Rather, what it is a package for rules, and therefore, when we start bandying it about without clarifying, it can lead to some purposeful misunderstandings. The Global South, in a general term, understood res communis to qualify space as common property, to limit its free use in a way that enables freedom of access for them too, equality of opportunity. But also, and these last 4 points are important, something that invoked equity, environmental preservation, a sense of global governance, and a sense of a collective with rights or at least in legitimate interests in space. All 4 of these are the main elements of the common heritage of mankind, another idea that we only really remember as coming to the fore after space or in the UN Convention on the Law of the Sea discussions. And all of these are a lot thicker of a concept of the commons than the global north was prepared to allow. They saw space much more as a place of bare freedoms where they could do what they liked, a sort of wild west where the law didn't apply. A historian of kind of colonial history or history of international legal application in an exterritorial sense may recognize this. There is a distinct urge to create a zone in which law doesn't apply and we can do what we like, or as Americans call it now, Guantanamo. And this became quite a troubling thing for a people that consider themselves to belong to a space age. I want to mention something important here, which is that all of this kind of argumentation I'm making now comes from a very kind of detailed analysis of the language happening in the Travo as we would generally paint it. That is the UN space debates, both in the GA and in the more exclusive Committee on the Peaceful Uses of Outer Space. But it also comes from a deeper historical analysis I'll mention in a minute. But even in this surface level Travo, the states active in the space debates were not subtle about clarifying this perspective. They very much outwardly said, hi, we're saying res communis in a much thicker way than you are thinking of it. And this is sort of the contribution that we're making to this debate. That counts as state practice under international legal doctrine, and yet doesn't seem to paint or move the needle in a current sense of what space law is or says. Now, the sort of loss that we have here is because the practice of space law that we remember is only East and West, we lose a lot of understanding of how communal land management worked in the South. Specifically, Africa was largely uninvited from the space debates. Only 4 states were present before sort of the mic was taken from the UN committee and things became non-binding. Only 4 states got to really be present. And of them, 3 of the 4 were rarely present, and at least 1 or 2 were actively discouraged from attending. So really, it was the United Arab Republic that remained the active state involved. I'll go into that in a minute. And that's a pity, because south of the Sahara, there was a very sort of rich expertise in communal land management that had existed for millennia beforehand that we could have really have used or at least learned from when we were talking about how to manage an area beyond national jurisdiction in the 60s. And indeed, we still have much to learn. Finally, the ways of talking about international law differed. As the Mexican ambassador said, the idea of international law as a set of bare principles that allowed justice, as opposed to a set of rules that were the minimum acceptable binding standards that powers would admit to constrain themselves to. Those 2 ideas of what law should be came to the fore in the space debates, and one of them won, and it wasn't the kind of principles and justice-laden idea that the Mexican delegate put forward. Finally, we come to authority. I want to mention briefly sort of, or rather go back to sort of our discussion on Travo and what makes it. Because in the UN space debates and in international lawmaking in general, there's quite a bit of ambiguity. And indeed, a lot of kind of treaty textbooks now will tell you that you're not doing responsible advocacy if at the ICJ, for instance, you don't bring up Travo, right? It seems to be something that, although it is supplementary, is also something that is in practice required. But what we consider to be Travo is sort of the crux of the matter. Because if you look at the UN space debates in only the sense of the UN Committee on the Peaceful Uses, only examine that TRAVO, even there is marked disagreement about, or marked variance rather, about what space should be, but it's also a very narrow window into the worldview at the time and since. Even if you look at the GA as well, also a marked and narrow window, because a lot of the states that were even UN members at the time in the 60s, and that was a changing thing, even the states that were members often couldn't go to the UN on a regular basis, or Geneva, New York, on a regular basis, just for budgetary reasons. One of the kind of smartest things that the later space debates did in the 1980s, talking sort of more about telecommunications resources, is start to have pre-meetings in Geneva, which effectively excluded the entirety of the global South that couldn't afford to not send people to Geneva not once, but twice. There was, to conclude, a lot of sort of exclusion happening that enabled certain kinds or versions of the law to dominate. This exclusion, like I've said, was political. The entirety of the space debates early, or the UN committee's early composition, was in fact, if you look at the TRAVO, was a random selection of states based on ability and geographic distribution. But here's the thing, if you look at the internal memos going on in the State Department at the time in the US, it was entirely decided on who voted for what China during the late 50s. The supporters of Taiwan at the time were invited to join the space debates because of a presupposed idea that they would vote for the US's side of things. And any state that had been neutral or voted against Taiwan or for the representation of the PRC was horse traded between the US and Soviet Union. That's not an issue that relates to space in any way, but definitely sets the scene for who was able to participate. At one point, the conversation incidentally became about whether Finland or Indonesia would be included. And in the end, neither was. Lebanon was instead. That was the kind of horse trade we're talking about. There was also exclusion on racial and colonial lines. The African problem, as they were called in internal memos at the time, both in the US, UK, actually also France, they were called African problems, and they were generally, the African delegates in the UN were generally seen as quote, emotional or immature, or raising issues that the US thought were not important, like the mass human rights violations going on at the time. And so in general, their participation in specialized bodies like the Committee on the Peaceful Uses of Outer Space, but also others, were seen as undesirable because they would distract matters. There was also exclusion happening on racial lines in terms of where things were happening. There was an sort of unremembered history of delegates from African states being racially profiled in New York City constantly during GAs, during other UN events. And actually the State Department had a designated portion of its regular reporting on the problems that were being reported in terms of who could access what schools all through the 50s and 60s. Remember, in the US, this was also quite a hot button issue. And finally, there were international institutional ways of excluding delegates. The Institut de Droit International at first only allowed African states in as associate members without voting rights. That was also something the US and UK proposed for the UN, but that didn't go through. And the ways that invitations were extended, for instance, as bilateral negotiations happened between the US and Soviet Union to make space law, they would set the agenda based on how relations were. For instance, when the Outer Space Treaty was being negotiated in private and in secret all through July to November 1966, the sort of regular meeting of the Committee on the Peaceful Uses of Outer Space was entirely set, like the date of it was set by when they thought they would be in agreement, which is incredibly awkward and hard to manage if you are somebody who works on a national budget in Senegal, Sierra Leone, or Chad, and needs to determine when exactly to buy flights. There is also a great deal of censorship going on, both by states in terms of when states like India, for instance, were prepared to submit proposals that would lead to the Outer Space Treaty, submit their own drafts, in other words, there were often internal memos going on amongst the powers saying, this is what they've shown us beforehand. What should we help them say instead? More troublingly, there is a great deal of censorship going on by the UN itself. Like I mentioned, Kurz has a paper on how this factored in discussions on the Holocaust in the UN in the 40s. And I've seen evidence of it as well within the space debates. Emotional or rhetorical flourishes were things that were culled when records were being taken from verbatim to summary. This is problematic because almost every history of international law, and especially outer space law, will cite summary records instead of verbatim, because international lawyers make poor historians. That is, I'm saying that's provocative, but of course that's not true. So what this means is that the UN effectively was taking points they saw as less important or more emotional. And again, emotional was a term that was often used to describe those who'd been colonized. And they were taking them out of the record. So in the end, we get to a point where space law itself was both unprecedentedly inclusive, but also unprecedentedly exclusive in terms of how it was made. There was it was produced almost entirely on a bilateral basis between the US and Soviet Union, treating the global South almost like a constituency instead of as a group of agents with points to make. And moreover, it was treated, the Travaux was a sort of choreographed exercise of rhetorical contributions that didn't necessarily give the clarification the VCLT implies. If you want to examine sort of the impact of authority in international lawmaking, it seems a lot more important to look at things like internal memos and who was saying what than it does to look at the record of what was said in the actual room. So in conclusion, the ways that outer space law was this is the sort of ending of the story of the Outer Space Treaty, at least, which is that within the UN Space Committee, in 1966 especially, the Outer Space Treaty became sort of a suddenly possible thing based exclusively on a kind of better relationship between the US and Soviet Union. They started getting along and also started realizing that their military aspirations in space were a lot more focused on reconnaissance satellites, which were immediately used to examine global South resources, rather than sort of direct military confrontation. And over the 60s, and if you look at the historical record, as the global South became a more kind of threatening global actor, US and Soviet Union started cooperating a lot more, often in ways that either coincidentally or purposely excluded the South. And when it came to actually debating the Outer Space Treaty, what ended up happening was that the US and Soviet Union came together and negotiated a basic draft. Then the US showed what they called the Friendly 15. First, by the way, just Canada, Australia, and the UK, which implies a whiteness I won't go into right now. They showed them the draft first, then the rest of the Friendly 15. And finally, the committee in general, once it was pretty much already written. The USSR did more or less the same thing with their sphere of influence. And the parties left out, as you can see here, was Africa and India. Now, what needs to be said here is this meant that the contributions the Global South could make to space law proper were incredibly limited. In fact, from my sort of record analysis of who raised what points, only 9 words of the first 3 space treaties were contributed by a Global South state, namely Brazil. And the part they contributed was the part of Article 1 I showed you earlier, that space should be allowed to benefit all, quote, irrespective of their economic and scientific development. Everything else in the treaties was a horse trade between the East and West in ways that the South couldn't contribute to effectively. And again, this rendered them a mere constituency to rubber stamp the product of bilateral relations rather than global actors in their own right with things to say and help to give. The ways that we define Travo really impact the ways that we think about something like the commons, but also the ways that we read a multilateral treaty. If we only look at the sort of choreographed example from the UN record, we're going to see a paragon of international collaboration and maybe some points that seem different but aren't picked up on anywhere else. The random speech by Brazil that seems to differ, for instance. But in general, it will seem quite a lot more like the idea of a treaty as an agreement. If you look any further, though, if you scratch the surface into internal records or confidential memos or anything sort of more deeply historical, you start to see where the kind of battle lines were drawn and who, more importantly, was not included. And in that way, the ways that authority works in space law making, namely who is able to say what the law is, become very important. Finally, I want to conclude on subsequent practice as sort of the main mover of space law now. At the moment, we are not likely to see a lot of binding treaties applicable in space in the near future. And what that means is that it's unlikely we're going to see much more than interpretation as a lawmaking exercise. And here's the problem, is that pretty much shows us this exact same picture. The US, and in this case now China, the more active states in space, will have the ability to predetermine how certain rules should be read. And because we don't remember anymore, or rather have memory hold, to use an Orwellian term, the different understandings of space that did arise in the past, that state practice is no longer included in what we would call a subsequent practice or relevant practice to develop custom. So in conclusion, which I think I've said about 10 times, there is no sacred timeline. The ways that we remember space need to be diversified and decolonized. But more importantly, the ways that we think about multilateral treaties, because for instance, environmental law came after, sort of the law of the sea came after, they all learned from this experience. The ways that we read those treaties need to be with a lot more salt. We need to make sure that we are picturing the contestations between the lines rather than the agreements were in black and white, and see them for what they are, which is the remnants of a battlefield, not the sort of utopia that they want us to imagine. Thank you.
Thanks so much, Chris. That was super interesting and I learned a ton. I'm just going to encourage those who have questions to put them into the Q&A. And I have a question here now.
One quick thing. I didn't want to spam my slides with like endless quotes. So if anyone wants, as a question, like, do you have a source to justify this? Please let me know. It's always hard in a PowerPoint.
Absolutely. All right. I already have a question, which is wonderful. In this era, all of the space activity was done by governments. How does the advent of commercial activity in space affect the current landscape? And if I could just add, and thinking about the interpretation of space law in the way that you are proposing.
That's an excellent question. So first of all, there's a slight myth here, which is that commercial space activity wasn't foreseen in the making of space law, which is more or less untrue, or partially untrue. Again, two things true at once. This was actually a political football that was used to make a point that the Soviet Union was very much insistent that space be the domain of states only. And the Global South was too, in a lot of ways. I say Global South is a monolith, but a lot of the states there, and in the GA in general, were saying, you know, the corporate kind of, there was a distinct tendency away from the corporate colonialism that they'd experienced. And again, as a Dutchman, there's histories there. Whereas the sort of US and friends from the 60s, there is documentary evidence that they were planning corporate expansion in space. That was a policy point of the US to expand corporate space activities from 1959, from almost pretty much the beginning, because that was a way that sort of their vision of the world could be expanded to. Now, that being said, the ways that space law is interpreted now, and again, the bare fact that at the moment, private companies are the most prolific space actors by far. Under outer space law, the Outer Space Treaty, Article 8, or 6, I always switch the two, but outer space law specifies that there must be continuous authorization and continuous supervision of private actors in space, which in theory would imply that there's a sort of delegated government or state kind of responsibility there, if you're going to use the ILC's articles and state responsibility language, and would in theory imply that the ways that space actors operate in space are almost proxy for state activity. That link isn't clear, and Melissa Durkee from the University of Georgia is someone writing a lot about that in fascinating ways. But it would seem to suggest that what SpaceX does in space could, in at least maybe now and perhaps in the future, be kind of linked back to their state of incorporation. Yeah, does that answer the question? Is that?
It's also a complex question, so I think yes, it does. Another question is, do you think that within the understanding of space law today, there's a growing awareness about the sorts of things you're talking about the need to look further, to look deeper, to understand the Global South views, either the past views of the Global South or the current views? Or do you think we're stuck in space law and it's just largely kind of stuck in the views of the global North, if I can put it that way?
So yeah, this is kind of the crux of it, isn't it? The US defined common heritage in '69 in an internal memo as basically first come, first serve. There's literally a one-line quote of like, common heritage to us means those who are active first can claim, which is fascinating because at the same time, the Global South was using it as a weapon. The commons as an idea have always historically been used as a weapon of dispossession, as a way of saying we're universal and therefore your land is ours, in the case of the New World, for instance, or a way of saying this international law we've formed applies to you ipso facto, like with no qualification, as the new states in the 60s found. Only in the space debates, maybe early law of the sea discussions and sort of trade related stuff in the late 60s, only in that time period has the commons actually turned to be a tool of the dispossessed, to say, now actually this land is ours and it means something. But the problem there is that way of understanding the commons has been undone in slow but clever ways. And it's hard to get that back. The sort of actually making the common heritage apply worldwide is what Bejawi called the tremendous revolution, which is something I just love. And it sort of is an idea that's been, to borrow a word from Dr. Vidya Kumar, has been largely genreified into tragedy. We tell the story of the commons, the common heritage, and indeed space law as something that ended poorly. So from the start, we know how it goes. And as we tell that story as something that is episodic and locked in the past. And so we don't see it as something that came from somewhere or developed something. And therefore, all of the parts of it that I've been mentioning and mentioned elsewhere in my research are seen as not relevant anymore. I think the one thing that really is important, though, if we are going to try and reclaim those histories, is from a doctrinal sense to remember what state practice means and why we look at Travo, to clarify ambiguity. And no one will deny, even the most ardent enemies of the space commons, no one will deny space law is ambiguous. If we remember what Travo is meant to do, then we know that we need to look at these histories, and we need to look at all the histories that matter. And that would include, in theory, state practice from the South. Maybe that can move the needle in a doctrinal legal sense. And from a critical perspective, we need to make sure that we're realizing the limitations of the documents we're reading, and also really give emphasis to the people who are in the position of the dispossessed then. What I'm trying to say here is civil society and indigenous peoples have representatives, as you and I've talked about, have representatives that are trying to give their voice kind of to the space debates now. We need to make sure we're listening, and that we kind of remember that, to conclude, intergenerational rights or equity, the idea that the unborn sort of in the future have the same freedoms and rights we do, that includes the freedom to think differently. And the idea is that people that don't look, act, or believe the same things we do will still get the same benefits. And that includes thicker understandings of the space commons. If you just think of 10 years ago, the ideas like the right to environment were a laughing stock. It was a joke. And now they're a core part of our discourse. And I don't even want to, I can't predict at all how discourse on kind of our shared spaces, literally and figuratively, will change in 10 years' time.
Which makes it a very exciting area of law to follow, for sure. I've got some good questions, but before I get to those, you were describing the horse trading that was going on with respect to the members of the UN Committee on the Peaceful Uses of Outer Space. Could you just explain, sort of go one step further? You talked about the horse trading, but where does the invitation come from? Like, can a state go, in the past, could a state go to UNCOPUOS and say, I want to join? Or did they have to wait for an invitation? Like, how did that work?
Yeah, so the background here is that UNCOPUOS now is thought as a very inclusive body because it's very large now. It was very small then. All of the horse trading that happened was done in the late 50s, I believe autumn to winter of 59, behind the scenes. And so actually the states invited never knew. Maybe the UK, France, and Australia and Canada did actually, because they collaborated more with the US than others. But then at the time, they were just there. And there was discussion in the GA amongst the general international community when they would report to them. States would come up, and states like Haiti and Indonesia were giving views on space that I think now deserve remembering. And like I showed in the slideshow, El Salvador made what I think is the most rhetorically beautiful speech the UN's ever seen about what space should be. But anyway, since then, actually in the 70s, certain states came forward and said, we would also like to join. The Netherlands was one of them, for instance, and also both Germanys, because at the time there were two. The concern was that China would also want to join as well. And at that time, the US had a policy of excluding them from as much as possible, the PRC. And so at the time, the US adopted policies explicitly against expanding UNCOPUOS and actually communicated with the Soviet Union to agree on that point. It was a lot more preferred that the UNCOPUOS could be a sort of choreographed exercise, a managed internationalism, exactly like they had done in the 50s and before, between certain powers. And so it took a while for that to start happening, and only in the mid-70s did it suddenly explode. Now, you and I can read consensus however we like. In some ways, it meant that India and Brazil had a veto, but they were also the ones that had the most to benefit from the rule of law in space because they weren't going to be active there immediately. And so it was a ticking, they were holding a time bomb. They had the right to, continue holding, but it was maybe better just to allow the powers to agree. And consensus, once the UNCOPUOS sort of expanded, became the limiting factor. It was the built-in kind of problem where now, in order for anything meaningful to pass, everyone must agree. And so in another way, again, the Global South was muted.
Thank you. Okay, here's another question we got in the Q&A.
I'll try to be shorter.
Thank you for the insightful presentation. Regarding new interpretation of space law, how do you think this could be done in a more inclusive way? Do you think it's possible inside the UN framework? And do you think that bilateral agreements like the Artemis Accords or the memorandum of understanding between China and Russia will be the only patterns of space law in the future?
That's fascinating. I'm going to briefly share my screen again. So the fascinating thing that most space lawyers won't tell you is that there are a lot of bilateral treaties. These are only some that talk about space. And they're between states like Argentina and India, Kazakhstan and Israel, Argentina and Ecuador. And so it's maybe important to realize that ideas like damage or concepts that were defined in limited ways back then through the VCLT norms we love and pray to are being developed now behind the scenes in ways we don't look at too much. But there's also a danger here. The Artemis Accords weirdly aren't a treaty necessarily. And so although they're being talked about like a treaty, they don't have the same legal effect. What they do have, incidentally, it doesn't need to be a treaty to be a subsequent agreement, according to a lot of sort of treaty lawyers. The fact that it uses agreement instead of treaty in the VCLT language implies that the Artemis Accords could in fact have some sort of needle moving effect in the international normative sense. But it does mean that the US basically wrote a rule book and is saying, hi, would you like to sign it? As opposed to an actual debate or negotiation. It also means that there's a lot so in conclusion, bilateral agreements have the propensity to allow sort of states that have previously been silenced to speak, but they just as well have an immense ability to exclude them from debate. And we know in situations where two things are true at once, which one wins.
Thanks. I'm going to try and fit in 2 more questions in the 7 minutes we have left. One is on space debris. So given what you showed us at the very beginning of your slides on space debris, how could space debris be dealt with in an inclusive manner, taking into account the views of the global South? What would be your take on that? Or maybe it's too, obviously I'm jumping to the present, but.
Space debris is going to benefit a lot from environmental law. I wrote my first thesis like 7 years ago about environmental law in space and EIAs for space debris and the right to environment in space, and was seen as, I got literally laughed at by a rocket scientist or two in that process, but now is something we're talking about. Global South jurisprudence on the right to environments is really active. Jillian Lin and Jacqueline Peel have a great symposium about this. And I think that the ways that the Global South can best move the needle here, and Indigenous peoples too, and they're already doing this, is to start really making more litigation and claims about the right to environment. And then as we see space as an environment, we start to look up with that toolbox.
Excellent. Last question. It has to do actually with Earth. How does the existing law regulate space done on Earth? For example, on the co-option of land, for antennas, or does it ignore this or turn to justifications of development? So that's an interesting question, just because if you think about what you're asking, which is to recognize multiple truths at once with respect to the views of the global South, in comparison to the views of the global North, which are dominating, how does that or can that translate to when we talk about space law that has to be, Earth law related to space, terrestrial law related to space issues?
Yeah. Okay. So for instance, when I've been working with this working group on this sort of dark and quiet skies issue, and this has somewhat come up. A lot of the early discussions on space benefits were framed in terms of the interests of astronomers, current and future. We need to make sure that and Article 9 of the Outer Space Treaty says this almost explicitly, we need to make sure that we don't contaminate space for experimental or scientific loss reasons. We don't look at those as specific instances of culture, right? And in space discourse a lot of the time, and I think also in like environmental discourse and the law of the seas, for instance, we talk about scientific benefits and cultural factors or cultural losses. But of course, that's sort of an emblematic aspect of the same problem, which is that science doesn't recognize its own colonial past. And the ideas of going to sort of formerly colonized places, a lot of the sort of launch sites and things that you see were originally made or planned when European countries had claimed ownership over those places, right? There is a continuity here that is troubling. And in a lot of senses, what we're doing is the same exercise, but now when we're talking about the dark and quiet skies issue, which is the opposite of a sort of space issue impacting Earth, but in the other way, but also in terms of like the launch center in Brazil that's being constructed to explicitly displace indigenous peoples, and the sort of observatory discourse that's going on in Hawaii. We seem very comfortable with using international law again as a tool of dispossession because it benefits us all. And I think we need to make sure that, I think the benefit of understanding space as a thicker sort of commons, as something we share and that implies obligations, is something that could help us a lot in how we think about the ways we use space on Earth.
Thanks so much, Chris. This has been absolutely fascinating and mind-opening, and really your research, I believe, represents what is hopefully only the beginning of the opening up, the decolonization of space law, and the recognition of critical voices within space law. So thank you. And thank you to everyone who attended. And I hope that everyone has a good rest of day. Take care.
Thanks as well.
Bye.
See you. Bye.